Thinking of selling your house on your own? Then you may have 21 questions to ask yourself. So the standard New Hampshire purchase and sale agreement has a lot of blanks in it. Only one of them is the price. There are 21 other important terms that can help determine whether an offer that you get is strong or weak, and whether you'll be able to get to the closing table with that buyer. The first one is, who are the buyer and who are the seller? Now, obviously you know who you are, but if you're selling in an estate or out of a trust, or if the buyer is purchasing with an LLC, there are steps you'll need to take to make sure that you get smoothly to the finish line at closing. The next one is the property. The most important thing there is the deed reference that you write in the purchase and sale agreement. The deed is the only legal description of what you're actually selling and what the buyer is buying. So you want to make sure you get that right. You don't want to sell the wrong property. And then of course there's price. High price good, low price bad. But will it appraise? That's another question you have to ask. And how much of a deposit is the buyer willing to provide you to give you a little bit of security through the transaction? How much should it be? How quickly should they deliver that to you? That's another question. And then who gets to hold that? It must be a neutral party to act as the escrow agent. So if you're selling on your own, you as the seller can't hold those funds. So you need to find somebody, possibly the title company, to do that for you. Another blank on the purchase and sale agreement is, what type of deed are you conveying it with? Now that may depend on how you got it. Maybe you got it with a warranty deed, could be a special warranty deed, a quitclaim deed, foreclosure, fiduciary. So you want to make sure you get that information correct as well. The closing date is the next one. You probably know when you want to close, but when can the buyer close? Do they have a house they need to sell first? Do they have to break a lease? How will that timing work? How long will it take the lender to get their financing confirmed and make sure you can get to closing? And then where you close is always an option. Usually that will be with a title company if there's no realtor involved. Some people like to close at the registry of deeds, but they may be closed due to a pandemic or something like that. So you want to make sure you get that set up. Next section of the purchase and sale agreement, or P&S, is the possession clause. So usually the house should be empty, broom clean condition before the buyer moves in. What about that paint that matches the living room? Can you leave that? Well, that's a good question. Section 7 is representation. If you're selling on your own, you represent yourself. If the buyer has an agent, what do you know about that agent? Are they a strong agent? Do they have experience? How do you find that out? Section 8 is the insurance clause, and there is a blank where you can put a dollar threshold in there. That's actually a clause I usually have to translate into English for my clients. It's oddly worded, but it is an important question, so you want to understand how to handle that. The next blank on the purchase and sale agreement are the inspections, and I could do a whole series of videos on inspections. The buyer will decide what kind of inspections they want to do, how long they need to get them done, and there are a lot of questions around those. So you really want to understand what the buyer is asking for and what you're obligating yourself for. There's also a section, number 15, for due diligence. That gives the buyer a chance to review the deed, look for easements, restrictions, make sure they can get homeowners insurance, won't need flood insurance. There's several options there. Review condo documents if you're selling a condo. And there's a blank for how long they have to get that done as well. And then you have section 19, the big blank for additional provisions. And anything can go in there. If your buyer needs to sell their house before they can purchase yours, that'll be specified in there, hopefully. A lot of buyers will put an appraisal contingency in there, so if the house doesn't appraise, they're not obligated to purchase the house at the agreed upon price, so you need to know how to handle that. Any number of things can go in there. And sometimes those provisions are not well worded. Lawyers cringe at what agents and buyers will sometimes write in there. So you really want to be careful about that as well, because that can cause some real issues. And then the last part is your signatures. That's the fun part. Now, if you're selling on your own, you can always hire an attorney to answer some of those questions. But attorneys aren't really going to know about how to handle inspection requests. What if the radon comes back high? What do you do then? Or, you know, which lender is trustworthy and which one is a little bit fly-by-night? and an attorney will cost you money, so you might as well pay an agent to help you do that part and answer all the questions in that purchase and sale agreement. If you do have any questions, feel free to reach out. I'm happy to help. If I don't represent you, I can't advise you necessarily, but I'm happy to answer questions whenever I can. And if you decide you don't want to tackle a transaction on your own, give me a call. I've got a great track record. I can share some of my client testimonials with you, and I'm always happy to help. Thanks so much.